welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Jose Estegaraga, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights, and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Hello, everyone, and welcome back to the latest edition of Arbitral Insights, our podcast series spotlighting the most inspirational people in the world of international arbitration. And I'm delighted to have with me today as our guest, Vasanti Selvaratnam, QC. Hello, Vasanti.
Hello, Gautam.
Vasanti will be known to so many of us. She deserves an introduction that I'm going to give her because she truly is an inspirational person and someone who I've been longing to have on this podcast series as one of our guests. She is a very eminent Queen's Counsel, made silk 20 years ago. She's joint head of 36 Stone and or 36 Group, a very prominent set of chambers in the UK, headquartered in London. She has a very varied practice in a number of areas of commercial law, is a mediator and also a very much in-demand international arbitrator. So I'm absolutely thrilled to have you here, Vasanti, and look forward to our chat on this podcast.
Well, thank you, Gautam, and thank you for the lovely introduction. It's great to be chatting with you.
It's very well deserved, I can tell you. I've known you for a long time, but never had a chance to do a podcast with you. So I'm looking forward to this one. So, Vasanti, you are, on any estimation, an incredibly distinguished lawyer and arbitrator. But let me try and take you right back to when it all began. And, one of the things I'm always fascinated when I speak to our guests on these podcast series is what inspired you to become a lawyer, Vasanti, in the first place? And who inspired you?
Yes, let me tell you this. I'm mixed heritage. I'm partly Sri Lankan, partly English, my dad being the Sri Lankan side of me. And my dad had a father who was a lawyer in Jaffna, but nobody on the Sri Lankan side of the family had followed in his footsteps. And I think my dad was really quite hopeful that I might show an aptitude for law. When my father came to the UK, he met my mother here in the late 40s. He was a trailblazer in his own right, and he had to make a lot of sacrifices financially to give me the best education that he could afford, and that involved him taking on more than one job. And as his only daughter, I felt that I wanted to make him proud of me. And I think that it really led from that. I wanted to find something which played to my strengths and which he could then say, yes, it's all been worth it. And to be honest, I was far too squeamish to think of becoming a doctor. And my mathematical skills were not such as to drive me towards accountancy.
Yeah.
So that really left law. And I must say, when I had graduated, I was at King's College London, both for my undergraduate degree and my master's. I had intended to go back to academic life and to teach international trade, shipping law. But to give myself more options in case academic life turned out not to suit me after all, I decided that I should complete my professional training either by taking the bar exams or the solicitor's finals. And at the end of the day, I decided to go for the bar because I could qualify in a shorter time. And it wasn't actually with the intention of entering practice at that stage. So it's quite fortuitous in a way. And it was really only once I started pupillage in a shipping set. I was a pupil to Michael Howard QC at Queen Elizabeth Building then. I experienced the excitement of crafting arguments that would be used in court and realised that being at the bar gives you the ability to shape the development of the law and have a real ability to shape the outcome of the case that you are acting in. And for me, that was it. Academic life really ceased to have the same appeal after that. And, once I was on the path, I haven't looked back.
Well, that's an incredible story. And so many of us are grateful that you did choose practice and not academia. So thank you for making that choice. So you've mentioned the inspirations, a few inspirations, I guess, you've had in your career so far as you were developing and building your practice. You've mentioned your parents, particularly their sacrifices they made for you. And that's something that so many of us, including myself, can certainly identify with wholeheartedly. And you've mentioned Michael Howard QC. Tell us a little bit about the mentors you've had at the bar, in the legal practice generally, who over the years have given you inspiration.
Well, I think the main person I really need to thank, and he's now long passed away, but was Geoffrey Bryce, QC. And he was head of my chambers until he died in 1999. He was my mentor and he led me in numerous shipping cases throughout my career as a junior. I mean, he was kind, he was inspirational, he was a big supporter of women. And it was largely thanks to him that we developed a chambers which was a big support network for women. He was very sort of far-sighted in that regard, and he was very equitable and fair. In terms of others, I must say I'm also a big fan of Lord Clark. I mean, he was formerly Anthony Clark QC, as you know, and he led me in my first big case. This was in the mid-80s, the Choco Star, that infamous case about agency of
Yes.
necessity.
Yeah.
And he, because he had a very busy practice, ended up being double booked for something. We were in the Court of Appeal and he wasn't there for the reply. And we were against a really very, very senior leader from Seven Kings Bench Walk on the other side, who was at least sort of 25 years older than me. And rather, he'd been in silk for 25 years, let alone being
Wow.
25 years older than me.
Yeah.
And Tony Clark said, "You'll be absolutely fine, Vasanti. You know this case." And he let me address the Court of Appeal in reply against this leader. And we won. And
What?
obviously, that's a great boost for confidence. And I was very grateful to him for trusting me with doing that. Now, as a leader, he was great fun to work with. And as a judge, I think he was second to none in terms of his temperament and his academic ability. And he also showed, because of his sense of fun, that you could be a really impressive lawyer at the top of your game and still enjoy life. It was not a total grind. And I think that was a great inspiration for me and many others, I'm sure.
Wow. Yeah, it's funny you say that about how Lord Clark sort of wasn't available. I remember when I was a bit younger, my then boss made himself unavailable, so I had to do something. So, which was absolutely fine because it meant me arguing something that I wasn't expecting to argue. So, very similar, but no way as distinguished as your intervention in the Court of Appeal. But, let me touch on something you spoke about a short while ago, Vasanti, which is about supporters of women. One of the many reasons why I'm overjoyed to have you on this podcast is because you are inspirational on many levels, but you are a very prominent, successful female lawyer. And there aren't many people of your seniority and your background, and you've mentioned your ethnic background, who are doing what you do. And I'm as passionate as you are about diversity, equality, and inclusion in its truest sense. I mean, again, for obvious reasons. I'd be really interested in your thoughts, just to pick up on what you said about, we all know diversity, equality, and inclusion is critical. And the legal profession, like many other professions, has to look like and feel like what it should do, given the makeup of our society generally. But I'd be interested in your thoughts as to, first of all, how you've seen this develop, because I can say in my 30-year career it's developed a lot, but I'm interested in your thoughts. And also, what more can we all be doing to ensure that we achieve the best possible diversity, equality, and inclusion?
It certainly has developed a lot, Gautam. You're absolutely right. In the mid-80s, when I came to the bar, women were very much in a minority. And I was fortunate in getting pupillage in a chambers where there were already two other successful women. we supported each other in terms of altering perceptions about how effective women could be in court, and also about how committed they were, because they were having families, but they were not giving up work in order to become full-time mums. So yes, it has changed a lot. I think in the 1980s, there tend to be a little bit of polarity. I mean, some women who were making it at the bar felt that they needed to become more like men. And so they didn't allow their feminine side to really show, and they were not really catering for family life. I think that changed over time. And I think at the bar, it's been much easier to have a family and a successful practice than perhaps it has been in a firm of solicitors. And again, that's another reason why I'm very grateful that I went to the bar, because you have, I think, the ability at the bar to take on as much or as little at any given time as you want, and nobody really notices. Whereas I think in a firm of solicitors, you have to be much more visible at your desk. And certainly I know of many very able female lawyers in firms who, because they were not able to have one day working from home, say, were forced to give up. And as a result, one has lost huge talent from, that side of the profession, because of really the inflexibility of attitudes that prevailed, back in the 90s and even into the 2000s, which didn't really affect people so much at the bar. But going forward, I think now we have a much healthier proportion of women in chambers, both commercial chambers as well as other chambers. And I think this reflects the fact that, women are now finding that they are able to compete on a more level playing field, but there's still a lot of work to be done. And it's an obvious and a given that there has to be equal opportunity for everybody based on their ability, irrespective of, their gender or ethnicity or any other irrelevant factor. And we all need to try and do our bit to make sure everybody who has that ability is given the opportunity, to grow in confidence and to shine. And I think, in chambers, I've certainly tried to do that, by mentoring younger members. The Pledge Initiative, which these solicitors have got behind in a great way, and the bar supports wholeheartedly, is very important. And that has achieved a great deal in terms of increasing visibility of women and people who are not from the usual backgrounds. When we sit as co-arbitrators, and I've certainly tried to do this myself, and we have the opportunity to suggest candidates for chair, I always try and include at least one, if not more, in that list, who come from a different background, be it a woman, be it somebody, who's from a different ethnic background, perhaps somebody who's not sat as chair before, so that they get a chance to show their talent, and then hopefully things can mushroom and kick off from there. And indeed, I've benefited from that. And I now have, a busy practice as arbitrator as a result. And I'm sure we can all do our bit for people that we can think of that are deserving and perhaps, might not think they're necessarily going to be, selected by people. But if you're given a chance to be showcased and you are diligent, prepare the brief, and you do your best and you're fair, then the chances are that you will get repeat appointments.
Yeah. Well, no, that's wonderful. Thank you. And, whilst I can't yet call you Dame Vasanti because you're not on the High Court bench, I wish you were, by the way, because you would be another trailblazer in that respect. You are obviously, as we've been talking about, a very experienced arbitrator, and you still maintain a counsel practice.
Yes.
And, that obviously means that life is, I'm sure, never boring for you professionally or something. So
That's right.
Because you've got lots of plates spinning in the air at any one time. But one of the things I've always been very fascinated about, and I'd be interested in your thoughts on, is taking those two roles of counsel and of arbitrator, and from your perspective, what each of those roles asks of you, the different things that it asks of you, and how you can in many ways switch hats and change tack from one to the other. I'd be very interested in your thoughts on that, Vasanti.
Yes. Well, I mean, both roles call for the same analytical skills as a lawyer. When you're acting as counsel, then the art of persuasion in argument is paramount, together with the ability to cross-examine effectively. And that in turn requires a very considerable amount of preparation before a hearing. So when you're acting as counsel, you really have to learn to survive on very little sleep. And that can sap your energy if you are full-time counsel and you're now, the sort of age that I am. And that's really partly why I have decided to combine counsel practice with arbitrator practice. And that mixed diet works very, very well for me. Now, as an arbitrator, your main job is to get the answer right and ensure the fairness of the process that you're presiding over. It isn't a combative role. It isn't a stressful role. And there's also an opportunity for really considerable collaboration if you're sitting in a panel, which is tremendously enjoyable. And I think contributes to the end product, i.e. the decision, being the right one. But at the bar, obviously, there is the adrenaline, the excitement of crafting the arguments, being at the front end of presenting the case. And it's tremendously enjoyable. And I still get a huge buzz from doing it. But I think in terms of just managing energy levels and making sure that life continues to be as enjoyable as it can be, I think a diet of both works for me very well indeed.
Yeah, no, I'm sure it is. But knowing you and your incredible levels of energy and stamina, I know you can do it all. I mean, so one last sort of thing I wanted to ask you about the whole arbitration area, and then I'm going to ask you sort of maybe a few more sort of different things. But arbitration as a mechanism for dispute resolution has obviously evolved over the years. It's now the most important dispute resolution mechanism for international business, for all the reasons which you and our listeners will be aware. But it's something that has to continue to evolve, and it has to be better and better so that the users of arbitration feel it's the best mechanism it can be.
Yes.
And there has been, as you know, Vasanti, a number of debates that are ongoing about should we be reforming various aspects of arbitration? What can we do to sharpen arbitration? Should we be amending the Arbitration Act? There's a number of things and ideas that have cropped up. And as you know, there's been for a long time a bit of a tension between how much the courts should intervene in arbitration and how much they shouldn't. The former Lord Chief Justice, Lord Thomas, obviously, as you know, felt there should perhaps be more intervention, and he got criticised for that. But this debate's a very fascinating one, and I'd be very interested in your thoughts, just given the incredible experience you have, as to, from your perspective, what more can we all do to ensure that arbitration is the best form of what it is, and what can we do to improve it, to make it better?
I mean, one of the things that I think is a bit of a sore in arbitration is the cost element. And I think costs are increased by an insistence on memorials, written memorials. I think they add a level of expense to the process which is not warranted. I mean, obviously, if the parties are insistent on memorials, then arbitrators have to listen. But I wonder whether that insistence is born of the fact that they've never tried doing a more commercial court style of pleadings, followed by witness statements and expert evidence, which I think is actually more efficient. I also think that we ought to consider costs at an early stage, like we do in disputes in the commercial court. So one would perhaps look at keeping costs to a budget and only increasing that budget if there's really good reason to do so because of unforeseeable developments in the case. And if you're looking at a budget to work to from the outset, then the chances are you're going to stick to it. I think also a way of keeping costs down is to make video conference hearings the norm even for final evidentiary hearings. I'm sure that most of us have done quite a number now over lockdown, on Zoom or Teams or whatever other platform. And, speaking for myself, although as counsel it perhaps is not as easy for those of us that like physical bundles and spreading out and standing and advocating, using your body, to make your arguments in quite the same way. I think you can learn to make it doable and effective. But I think as an arbitrator, I thought it was actually easier to focus and concentrate on the witness. And I didn't think there was any disadvantage to not having that witness physically present in a room for me to observe, because I have him on a tile. I'm looking at his or her face. I'm scrutinizing as to, whether somebody is having difficulty in formulating an answer. And I think that, video conference hearings for final evidentiary matters ought to be the way to go, unless there is really good reason not to. So, for example, if you've got fraud allegations and you need to have, a witness sort of scrutinized by everybody in the same room for demeanor, that may be an exception. But otherwise, I think go for the cheaper route, which will involve, not traveling for all of our international clients. I think also arbitrators should be encouraged to be more proactive. I'm thinking in particular here in shipping arbitrations, where it's a bit of a problem because there is no sort of initial procedural conference as there is in LCIA arbitrations, ICC arbitrations, SEAC arbitrations, where you set the procedural timetable at the outset and then you stick to it. Many LMA arbitrations, they simply appoint you and then it goes to sleep. And nobody really expects you to sort of, rattle the tin and say what's going on. They just want you to, sit there quietly and let the parties get on with it. And I think that isn't always the best way. I think there ought to perhaps be an initial CMC to set the procedural timetable. And then if people want to get extensions, they can explain that that's agreed and why. I mean, in terms of Arbitration Act amendments, I know that the Law Commission's looking into this, and I think it's healthy because we're now 25 years on and we need to make sure that it's going to be functioning in the best way. I mean, I've seen Section 67 appeals in particular, which have been hugely expensive, which have involved rerunning exactly the same arguments that were run below. And it's been done because it's permitted under the Act. And invariably, the arbitrator's decision has been respected, particularly where it's been based on fact. So looking at that again, I think could be quite helpful. I think also perhaps sidestepping the tribunal and going straight to court where it's a jurisdiction question could cut out a level of expense. So those are my initial thoughts on how we might make it more streamlined and perhaps make it more user-friendly.
All very insightful. Thank you, Vasanti. I mean, one of the other things just on that, just a limited point, just to follow on from that, which is that we've seen, as you of course know as well, very well, Vasanti, over the last few years, the introduction of expedited arbitration, under certain thresholds and that sort of thing. I've often thought, and UNCITRAL has just brought out its expedited rules, which actually don't have a financial limit on the amount of the claim, as compared to ICC, where it's $2 million and below.
Yes.
And I'm a fan of that in the appropriate sort of case. I mean, I wonder, of course, every case is different, Vasanti, be it shipping commodities, joint venture, power plant, whatever it is. But just your thought as to, do you think expedited arbitration might have a bigger use in some of these bigger disputes, assuming the parties can agree to it?
I do. I mean, I've just actually finished writing an award on an expedited arbitration. It was a small value one for SEAC, but I do think that it would benefit from being used more extensively after consultation with the parties and agreement, because it will obviously limit the amount of cost that can be spent on it. It does ensure everybody is focusing minds very closely on what the real issues are. And, I think, again, we ought to be looking at financial limits being higher than perhaps they are in appropriate cases where the issues are fairly straightforward.
Thank you, Vasanti. It's really, I could talk to you for ages, but these podcasts do have a time limit, unfortunately. And I could, as you know, I could chat to you for hours. But it's been absolutely fabulous to talk to you about those amazing things we've just spoken about. I wonder if I could finish off the podcast by asking you some more light-hearted things,
Of course.
which have got nothing to do with your incredible career and your career to come. But tell us, everyone's been through a terrible period, this lockdown. It's stopped us traveling and stuff, and things are gradually coming back to some level of, well, hopefully normality. But tell us, what is your favorite holiday destination?
Oh, that's easy to answer. That's got to be the island of Nevis in the Caribbean, which I have not visited since February 2020, and I'm desperate to get back. The wildlife there is wonderful. Beaches are amazing. And you feel that you can truly unwind and relax there. So that's the place for me.
Wow. Well, I've not been to Nevis. I've heard of St. Kitts and Nevis being one of those offshore jurisdictions, but I shall keep that on my holiday destination.
You probably heard about it in the context of money laundering. We'll talk about that side of it. But if you're just going as a tourist, it's lovely.
Oh, absolutely. Absolutely. No, that's definitely now on my bucket list. And so, when you've finished some hard submissions, you've finished listening to a day's argument as an arbitrator, and you want to put some music on, what is your go-to music selection or selections?
Oh, gosh. It does depend on my mood, but I think if I want to relax after court, it's got to be Baroque for me, and probably Bach, because that is just so soothing and it relaxes you and inspires you. But if I am wanting to get ready to go out somewhere, then it will be a question of maybe some pop with a great beat, or some jazz.
Yeah.
I've recently discovered I like jazz after having gone to Ronnie Scott's, and I'm now a firm fan. So yes, it depends on the mood.
Yeah. Oh, I love it. And my last question to you, Vasanti, is, I recently went to the cinema again after 2 years or so. I watched the new James Bond film. I must say it was pretty good, actually.
I've seen that too. I agree. I think it's the best Bond film.
Yeah, it was pretty good. It was a bit of a sad ending, but understandably sad in that sense.
Yes.
I won't spoil it for those who haven't seen it yet. But, is there one film that really stands out to you that if you were to get a chance to sort of have a bit of downtime and just watch it again, is there a film that you think, wow, that's the best film I've ever watched?
I think probably it's a film from the mid-90s called The English Patient.
Oh, yes.
Which has got two of my favourite actors, Ralph Fiennes and Kristen Scott Thomas.
Yeah.
Wonderful underlying story. Michael Ondaatje wrote the book. And it's impossibly romantic, beautifully filmed. And every time I watch it, I cry. I love it.
Yeah. Wow. Well, what a great way to finish the podcast. Vasanti, thank you very, very much for your time today. It really has been an absolute joy to have you on. I make no bones about it. I've been a massive admirer of yours. I respect you immensely. So having the chance to do this conversation with you on this podcast has been fabulous. So thank you very, very much.
Oh, thank you so much, Gautam. It's been great chatting with you.
Okay, see you soon. Bye-bye now.
Bye-bye.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email Jose Estigaraga at jia@reedsmith.com. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.